Thank you. My name is Jane Wagner. I am the Senior Staff Attorney for the Health Education and Law Project. I've spoken here a couple times before, and I always get the most exciting and uplifting topics, don't I, with family law and guardianships. So today we're going to be talking about family law, and just a reminder that family law is very fact-based, that I'm going through just general processes of how family law works and how it would integrate with the health system and how it affects you guys. But every case is a little bit different. And so if I always get, well, my sister or my whatever, it was totally different. And that's probably true. But I'm just going to give you a general overview of how we see it and how we process things and kind of the general process for family law and why it's important. So family law and healthcare, there's going to be 3 topics that I cover. I'm going to be covering divorce, custody, and protection orders. And so our big concern with family law is that is it a health-harming legal need that they have? Like, is there domestic violence in the home? Is there something that the stress of the being married to someone or having children with someone, is that causing stress to the patient? And that's what we look for, and that's what we try to help with. And so these 3 things are very different, but these are the main topics that we will cover or that we help patients with. And again, feel free to stop me anytime. I'm happy to answer any questions that you may have along the way. So our goal is to bring less violence into the home, which means that we help them with getting out of the abusive situation, or that we try to help them just stabilize their lives. And that may mean getting away from an abuser, or that may mean being able to have a parent make medical decisions on behalf of a child, anything like that. So we want to reduce that stress, and that stress, as many of us know, families do cause a little bit of stress in our lives. So in Nebraska, with divorce, it's a no-fault state. So I don't care if she cheated or if he stole, whatever. That does not matter. If you want to get divorced in Nebraska, you can get divorced for whatever reason. And we want to focus on, with a divorce, are there kids? Is there property? Is there debt? And that's going to be split up equitably. And I think when people hear that word, they mean, oh, like it's equal. That is not always the case. Equitable means fair. What would be fair? Does some person get more debt because they have a bigger 401k? Or what is that? How do we make things fair for each party? And for me, if not everyone's completely mad at each other by the end of it, I would call that fair. So to be able to file for divorce in Nebraska, you have to be living in Nebraska for at least 1 year prior. So if you just move here because you got out of a bad relationship or whatever the case is, you need to be a resident of Nebraska for 1 full calendar year before you are eligible to file in Nebraska. And some of the things that overlap that you may see here with patients is the domestic abuse situations, also spouses that have medical debts. So what's mine is yours, right? So if you're accruing medical debt when you are married, that is also yours. That is your partner's. That is both of yours accrued together. So when you get divorced, that's the type of debt that gets divided out or gets assigned to one person or the other. Substance abuse situations, that's a common one as well, is that people who are married to an addict, or that they are the addict, they need to get away from the situation to help their own situation. And also Medicaid. I think Medicaid is a big part of that. I think sometimes when you apply for Medicaid as a married couple, you have to, it's a couple of different ways you can apply for Medicaid as a married couple, but you have to report the spouse's income and what they have in their assets, because that may put you over the asset or income limit, the eligibility limit for Medicaid. And sometimes if you're estranged from your spouse, you don't know where they've been for the last 10 years, Medicaid will still require you to provide that because you are married. And so we work with DHHS in these type of situations. Sometimes we'll send them a copy of the complaint, or we'll do something just to show that the spouse is no longer in the picture or we're intending to file for divorce.
Do you have to file in the, like, if I got away from a situation and I moved to Nebraska and now I've lived here for a year, can I still file in Nebraska, or do I have to go back and file in the state I came from where he might be?
So if you came here, if you moved here in August of 2018, August 1st of 2018, as of August 1st of 2019, you then would be eligible to file for divorce here in Nebraska. That you've been here for 1 full calendar year, you are a resident here, and regardless of wherever the spouse is living, you would be able to file where you are, because the court would have personal jurisdiction over you. So how are benefits affected by a divorce? Again, we talked about Medicaid, but that also affects things like SNAP and ADC. You have to report that. Any household income. So if you're married, they still may require you to provide your spouse's income, whether you have it or not. And then also child support. I think a lot of things that we see with kids that are on SSI is that we see overpayments. That child support is not always consistent. It depends on the family or depends on the situation, but sometimes people will go months without any type of child support payment, and then one day you do get a payment. Well, that's income that you have to report to Social Security, or you cause what's called an overpayment, is that there was money coming into the child, because the child support is supposed to assist the child. That's money coming into the home, and that if you don't report that, that could potentially set you up to where Social Security is saying, we overpaid you for this month because you had income coming into the home that you did not report. Which, as very inconsistent as it is, as it could be, you still have to report it once you do actually receive it. And also, child support does affect benefits in the fact that there is, many of you know, there's a difference between SSDI, the Social Security Disability Insurance, and then also supplemental security income. SSDI, that disability insurance, if you qualify for that, you are your judgment proof from, medical debt or credit card debt. The creditors cannot touch that, but the state of Nebraska can. If you owe child support, that SSDI check can get garnished. And so sometimes we get it and we're able to negotiate with the state of Nebraska as far as a withholding, because the state can go in and take the SSDI portion of it to pay back child support. So what happens when a party is unhappy and wants to change their divorce? So let's say you have kids when really young kids and you get divorced when they're really young, 10 years later. Whatever parenting plan you had now, kids change, things change, situation has changed. What do you do now? There's a totally different circumstance, and the parenting plan that you may have had when they were kids does not affect them when they're teenagers. What do? You can do what's called a modification. So a modification is saying that from the time you were initially divorced till now, there's been a substantial change in circumstances. So what happened? One thing is maybe a parent went to jail and they haven't had any parenting time or something like that. Or let's say a parent moved out of state. That would be a substantial change in circumstance. But that is also something that we can look into, saying, has there been enough time passed and is there enough evidence to show that there has been a change of circumstances? And the best interests of the children are considered. A lot of the modifications, I think a common one, again, is moving out of the state. So you reevaluate what would be in the best interest of the children, what would be in the best interest of each parent as far as not affecting their relationship with the children when you move out of state. So a client story, Janelle was referred to help from her therapist. She was in an abusive relationship with a husband that struggled with alcoholism and had resisted divorce in the past. I think that's pretty common in domestic violence relationships, that the victim does not feel like they can come forward and actually follow through with this process. So it's really important, and it does mean a lot to be able to give them the strength to be able to go forward with this. And we were able to help her file for divorce, help her file a protection order, and be able to protect her from her abuser, and then also complete the divorce so that they can be completely separated. And you might notice a theme throughout my case stories. You can tell what TV shows I watch. So custody. Custody will be determined whether you're married or not and there are children involved. So there are two different types of custody. You can have legal custody and there's physical custody. So legal custody is who's going to make the decisions, medical decisions, religious decisions, where the child will go to school. So legal custody is important, especially for healthcare providers and hospitals, is that who do you look to? Who's going to make that decision? That what type of medical treatment or who can consent to treatment when you have a child? And so if someone has sole legal custody, you have one parent who's the only person making that decision. If it's joint legal custody, then both parents are making that decision. And now, if they probably do have to agree that people have to make that decision together, and that's why it's joint legal custody. But in some parenting plans, an option that people sometimes have, I've done it before, is that you may have joint legal custody, but there may be one parent that has the discretion to make the final decision. So if there is a disagreement, there might be one parent who has that final decision-making ability, which that would be in their divorce documents or custody documents showing who has what. And so the joint significance is that you can't cut the other parent out. They have to be informed, whether they act or not, that you have to inform them of this decision. Now, a lot of parenting plans and a lot of decrees, some standard language, especially for what I use, is that if there is an emergency situation, that a child comes into the emergency room or there is an emergency decision that does need to be made, whoever has the child at that moment can go ahead and make that emergency decision. Physical custody. So physical custody is who actually has a child. And so that's determined by the amount of nights. Where does the child sleep at night? And that could be sole physical custody. So a standard plan would be one parent has the child majority of the time, and the other parent has every other weekend and one day during the week. That's a pretty standard plan, that one parent would have sole physical custody. It could also be joint. So joint physical custody could mean that, again, it's by the number of nights. So I think it's about 142 nights would make it technically joint. But some joint custody arrangements would be if one parent has the child for 1 week and then you flip-flop. So 1 week off, 1 week off. It could be that you split the week in half or whatever the case is. But that's the difference between physical and legal. So in Nebraska, any child born to the marriage is presumed to be the husband's child. So even if you've been separated for 20 years and you haven't seen the guy, and you're a mom and you have a baby and you're still married to them, that your husband is presumed to be the dad until there is a decree saying that he's not. And in Nebraska, genetic testing is required to undo that. That even though you know 100% no way that he could be dad, he is dad legally. And so genetic testing has to be done to disestablish the paternity of the child to then allow the real biological father to then establish custody or paternity. If the parents are not married, so if you're not married and you have a child with someone, the mother of the child, when they give birth, they are not required to put the biological father on the birth certificate. By not doing that, they are not legally dad. So until dad files a paternity action or until they sign an acknowledgement of paternity, they are not dad legally. So if there is no father listed on the birth certificate, then they have no rights to the child until that's established. And in Nebraska, you have 4 years to establish paternity. So you can't, when they turn 16, say, oh yeah, you are my kid. I'm going to file for paternity. You are too late at that point. Which, if there's no paternity established, that also means that mom would not qualify for any type of child support. Because when the state comes in and files, they both ask for paternity and also child support. So what happens if there's not a custody order? So you just had a baby, or you've had maybe just an agreement between you and the other parent. So what happens if there's no custody order? That means that whoever has the child can keep the child. But if you are listed on the birth certificate that your dad, or that, let's say, if you're married and you were just separated at the time, you also don't have to return the child. And a common scenario is that a parent takes the child to school, shows up to pick them up, and they're not there because the other parent has gone and picked them up, which they can legally do without a custody order in place.
Can they go over state lines?
Well, if they're married, yeah.
Well, in the last scenario, if there's no custody agreement?
If there's no custody agreement and you are determined to be the legal parent, sure. And then at that point, it's you're hunting for that other person, which that's a tough situation. So a custody story that Macy was referred to help by her social worker. She had suffered a stroke, and the minor child had autism. She was only receiving SSDI at the time and raising the minor child. I think the minor child also had SSI. That was their only income to the household. Dad was not paying any type of child support, so we were able to help mom get full legal and physical custody of the child, and we were able to get child support and back child support for her. So that is an option as well. That's not always the case, but in this scenario it was. Any questions so far? Okay. Child support and paternity. So we talked about it a little bit. So if the, let's just say mother, let's say they give birth to the child, and the child starts receiving Medicaid, or mom starts receiving WIC, whatever the situation is, whatever type of state benefit, the state of Nebraska can move in and file for child support and to establish paternity. So when the state of Nebraska does that, they do not touch on custody. That's not within their realm. They're only establishing paternity, that they are the legal father, and that child support start since the child is receiving some type of state benefit. So whoever the child is physically living with at that time, that's who will be who will be receiving the child support. And so when the state initiates an action, it's usually just between the state and the non-custodial parent, so the parent who doesn't have the child. The other parent who does have the child, they're called a third party. That they'll know of the action, but they're really not required to do too much because they will just be receiving the child support. But that third party, so mom or dad or whoever the parent is that has the child, can certainly file for custody in that same action if they choose to do so, but the state will not do that. So child support. So I think some people, I had a scenario recently that my client said, well, he said he would give me the child if he's okay with just paying $500 in child support each month. I said, lawyers are not good at math. They don't leave that up to us. So they have a child support calculation. You put in one parent's income, you put in the other parent's income, and you put in if someone's paying health insurance, and it pops out a number. And that's the number that you use for child support. So it's not like I'm making up a number or I feel like this is appropriate number. That's not up to me. I put it in the calculator, and that's what pops out. And so the child support calculation can be done a couple of different ways depending on what type of custody is there. So physical custody. So in a joint custody situation, each parent having essentially equal time with the child, the court looks at, well, each parent is equally contributing. So the type of child support that's calculated may be very little depending on the income of each party, or it could not be in effect at all. So that is just for child support. That does not include any type of daycare costs, school activities, school tuition, anything like that. Child care expenses are something that's done independently. So even if there's no child support ordered because you have joint custody with the other person, you still may be required to each pay. I usually do just split it, that everyone splits. You know, it was $100 for soccer this month. It was, you know, $20 for dance, something like that, that you split it 50-50 with the other party. But that's also determined within the calculation, that there might be a percentage that each parent is responsible for the child, and that might be the percentage that you'd have to pay for any type of daycare or anything like that. As many of you know, daycare is very expensive, so that is very important. And I think there is like a myth that sometimes people go into these actions, go into divorce actions, well, I'm just going to quit my job. That way they can't give me any type of child support, or that I won't be required to pay because I don't have a job. That's not necessarily true. You can still, if you are not disabled and there is nothing stopping you working from a full-time job, then you can at least, at a minimum, put you at minimum wage, that you are capable of working this amount. So child support modifications. So this is similar in a modification as if you had to modify the parenting plan, that there has been a big substantial change in circumstances, one parent moved out of state, whatever the case is, and you need to change the custody portion because things have changed. Same with child support. You can just modify the child support. So again, you'd have to show a material change in circumstances. So that would be something that you can show the court that is something that has lasted for 3 months, expected to last for at least 6, and that your income will not change from that. And so just losing your job one day, that may not be enough to modify your child support. Some things that may modify it is that if you are working full-time and you become disabled, that would be a change in circumstances. Or if you go to jail, that would be a change in circumstances. So we've done this before. Gary was referred to help by his physician. He was paying child support. He was working full-time. While he was working, he then became disabled and had only been receiving SSI, and I believe his child support payment was like $350 a month. Well, his SSI is $750, so that's a big chunk. And so he was unable to afford his payments. So we were able to modify it down to $50, which is the minimum that he would be paying per month. So when child support is ordered, it's kind of like a credit card. There's about a 4% interest that comes with it. So if you don't pay it, it's going to accrue interest. And that interest goes to the state. So it's a big deal to modify it, especially in cases like this, so that you don't have a continuing higher amount keep accruing, because that just buries the person in arrears. So what's past due child support, and that is accruing a lot of interest. And that's something that cannot be forgiven. In some situations, if the parties reconcile or whatever the case is, you can terminate guardianship and the payee parent can forgive part of the child support. But that interest that accrues, that cannot be forgiven. That is always going to be owed, because that is owed to the state.
Why doesn't the child get that?
Well, it goes to the state. So let's say if the child was receiving any type of Medicaid or anything like that, that would be essentially going back to the state for the benefits that were provided. That would make sense to go to the child, but that's how Nebraska works.
So how does it, like, does it just get tagged that there was a modification, or how do you know, like, to go back and check, like, if it needs to be re-modified back to what it was?
So if you're saying if it was like $350 and it got modified down to like $50 and that person went back to work full time or something, you can modify it again.
So like the other person would have to?
They wouldn't necessarily have to, but
They wanted more money again.
yes. So if they wanted more money and there was a lower amount that was previously ordered, and now they are working full time and they're making $100,000 a year, I would call that a substantial change in circumstance. So, either party can do so. If I was the one paying child support and I was only ordered to pay $50 and I was making a lot more money, I would not be very motivated to change that. because again, accruing the interest and if you're making income, that's potentially garnishable. So I would say you'd probably be more likely on the other parent to modify it and say, look, like they're making $100,000 a year now, this needs to be redone. An upward modification, that's what an upward is a little bit more difficult. You're going to have to show a lot more evidence to show that their income is a lot higher and it will continue to be higher. Protection order. So this one, there's two types. So there's a domestic protection order and there's a harassment protection order, an HPO. And these are not interchangeable. It's very important which one you file. I just had a client that said, I just grabbed whatever was there and I filled it out. It's very important to fill out the correct one. And if you're not sure, you're more than welcome to give us a call. But the domestic abuse protection order can be filed because it's against it depends on the relationship between the victim and the abuser. So the person wanting to file, if it's a significant other, if it's someone you have children with, if it's someone you're married to, if it's a household member, that would be someone that you would want to file a domestic protection order. And so the standard for that is you have to attempt to cause or intentionally and knowingly cause bodily injury, or placing by credible threat another person in fear of bodily injury, or also sexual abuse as well. So the importance of that one is that this one has a little bit more teeth. It's a little bit harder to get one. The standard is a little bit higher, but this one is very important because not only does it protect the victim, but children can also be put on it, and you can have custody ordered for 90 days in that. So it's very important to pick which one properly. A harassment protection order is that that you're harassing or making threats or intimidating another person. So you can file a harassment protection order against anybody. You can do it against your neighbor, or you can do it against your ex-boyfriend's girlfriend, something like that. That does not depend upon the relationship. But that one, they're both good for a year, but the harassment protection order does have a lower standard, and it doesn't have as much teeth as the domestic protection order because that one's just saying, leave each other alone. Don't be jerks to each other, leave each other alone. But the protection order not only helps the victim be able to get out, and that does cross over state lines. So if a victim gets a protection order here and decides to move to South Dakota, that will still protect that victim. And that may give custody of the children and everything, and would allow him or her to move out of the state and still be protected from the abuser.
The harassment order doesn't cross state lines, though?
It should, yes, but I think it will. But again, it's a little bit lower of a standard. And what's important about these two as well is that if you violate a protection order, you can get charged with a felony if you violate that. I think there's also, I don't know if it's a misdemeanor. If you violate a harassment protection order, you can still violate it. But I think that those are not as high of priority, or may not be. I haven't really seen one that's been violated, but the protection orders are taken very seriously. So how to obtain one? So usually the court has like a packet in Douglas County or Sarpy County here. They have a packet that the person would have to fill out. And if you ever have a patient who wants to fill out one, we're more than happy to help them fill it out. I think it's important to sit down and figure out what specifically needs to go in there, how recent were these events, and help this victim put together their thoughts in a way that would help them. Because you get 3 paragraphs. That's it. And if you're handwriting this, you may not get across everything that's actually been happening. And we're able to collect your thoughts and put it in a way that would benefit you, and maybe it's a little bit easier to tell your story to someone as a patient and have them kind of rewrite it in a way that would make more sense. So you file the form. So the affidavit, so your 3 paragraphs that you tell the court what happened, That's what your protection order is based upon. So whatever else is outside of there, the court will not look at. They're going to look at the four corners of what is within this affidavit, what is on this one page, and does it actually need a PO. And so you won't see the judge. Once you file it and put it in, you may not see the judge. And it's an ex parte order, so it's an emergency order that the court will look at your affidavit and then make a determination on whether an ex parte order should be put into place or not. And that's why that affidavit is so very important as well. That's the only thing they see unless there's a hearing. Then the victim would be able to testify, but that may or may not happen. So once the court reviews it, they have the opportunity to just straight up deny it, that they're saying there's not enough evidence, I'm going to deny it. Or they can set it for a hearing. They say, I don't think there's enough here, or maybe they have some questions about some things. The court can just set it directly for a hearing. It can get denied or an ex parte. That means that it's put into effect as soon as the person gets served. Service is a very important part because it does you no good unless the abuser gets served by a sheriff.
Do you see those get denied very often?
Depends on what's in there. I think that what I think does not help a person be more successful in those is that we look at the time of these incidents. So if you listed time from last year, if you said August of 2018, this happened, that's not very good evidence, and that's unlikely that's going to get approved based upon that one thing. Well, if you list something that happened maybe last week, that would give you a better opportunity. Timing is very important. So I always try to keep within the last 3 months, maybe 6, depending on what the situation is. And then you serve them. So if there's a hearing or an ex parte order has gone into place, you need to get them served. You have 6 months to get them served. Or else it's not worth you filing because it won't be in effect until that other person gets notice. And so once you get served with that protection order, you have an opportunity to say, I would like a hearing. You have 5 days to return that form, saying, I request a hearing, I don't agree what's in here. If you do not, then you waive that right, and that's put into effect for 1 year. So protection orders, again, that will protect a victim from an abuser. And in those domestic protection orders, they can say they can't go to the school, they can't go to this person's work, they can't go to the home, they can't go to the daycare. There's a little bit more leeway in how that protects that person. And so you, as employees of the hospital, that's an important thing to know whether there's a protection order or not, because then you can prevent them from coming in the hospital. They can't be in the same place that they are.
So what if there's a protection order and the guy, the guy is calling and sweet talking, manipulating the gal, and then he does come up, because she lets him, is that still a violation then of the protection order?
Absolutely. Either party can violate their own protection order. Absolutely. It could be either person, the abuser or the victim. And that does happen, especially in domestic violence relationships, that you're in this cycle that, the abuser knows how to manipulate you and knows how to get back in. But either party can violate their own protection order. I think it's especially hard, maybe not as much in Omaha, but Omaha is kind of a small town. In a lot of our smaller towns, go to the grocery store, but there's only one grocery store, and so you run into each other there. But if that happens, you need to just walk away.
Are we, as healthcare providers, if we know that they have a protection order and it's being violated, do we have an obligation to turn them into the courts, or just have them removed from the hospital? What's our role?
I don't know if that would fall under your mandatory reporting. I wouldn't think so.
How
No.
Let's pretend they were talking to us and they said it out loud.
Right. I don't think that would be something that would fall under mandatory reporting. I would not think so. I could be wrong, but that's my gut feeling is.
Have security remove them or.
Right. Yeah. You can. And I would, if you have a patient that's doing that, it's in effect. And if you violate it or if you then dismiss it, it's really difficult to get another one against that person. We always make sure that 100% that they know that this is the decision that they want to make and they're making it on their own and hopefully not being as manipulated. But it's really difficult because if they dismiss it, when you file for another one, that dismissal will show up when you file for another one. So you have to be very, very careful on how you do that.
What's the consequence for that?
It's a felony. You can get charged with a felony. So, most of the time, majority of the time, if it's your first offense and you violated a PO, you'll get charged with a felony, but most likely you'll get dropped down to a misdemeanor for disturbing the peace. But that's an important part because if you ever needed to file for custody or divorce and someone had violated a PO, that's good evidence to bring in that this person obviously doesn't care about a court order. And if you have a protection order, I always tell whoever the victim is, keep it on your person, because if you need to call the police, you need to show them that this order is in effect because they can pick them up. That's a felony, or at least they can get charged with one. And potentially, they can get convicted or however that is. I don't do criminal law, but that's what happens. So again, court may order custody for 90 days. So even if there is some type of parenting plan or something, if the protection order gives you custody for 90 days, that's what you would have to keep the kids. But if your 90 days is up, but the children are still on the protection order, so let's say that you filed for yourself and your 2 children, custody is up, that still protects the kids from when they're at school, wherever they are, so that's good for 1 year. And in Nebraska now, I think this went into effect maybe a year or so ago, if you file a domestic protection order, you do have the ability to renew it at the end of the year. You would have to tell the court why you'd want to renew it and what your reasons are for it, but that is an opportunity that you have now. So Amber was referred to help our social worker after a hearing was requested. She had escaped an abusive relationship with her new baby. We were able to represent her and get the protection order affirmed. So if you request a hearing, these hearings happen fast. They have to happen within, I think it's within 10 days, but it's usually within a couple weeks. They happen quickly. So if you ever have a patient and they need to go to a hearing, the sooner we know, the better, so that we can properly prepare them. Because they're going to have to testify. And that's a difficult thing to ask, is that you're looking your abuser in the face and testifying against them. So we got to get them prepared. So if you see that, please send a referral. Please let us know right away, because the more we can help prep them, the better they're going to do. So how to help parents with terminal illnesses. So if a parent's been diagnosed with terminal illness or poor prognosis and they have children, what happens? What happens to them? A couple things that we can do are fairly easy is a last will. A last will, if you have minor children, you can nominate a guardian to take over. I think the big thing with the will, if you nominate a guardian, that is on the assumption that the biological parent, if they've legally been found as the biological parent, that they don't intend to act, that they don't want to take the kids, they are not enforcing their own rights, that they're not involved, and that will allow someone else, a grandparent or an aunt, uncle or something, to be able, whoever the client chooses or whoever the patient chooses to be guardian, that will allow them to file for guardianship paperwork and take over taking care of those kids. A temporary delegation of parental powers. We do this quite often. I'm sure you've seen it float around here. It's a one-page form that will allow someone to make medical decisions and other decisions on behalf of the children, and it's good for 6 months. The parent that signs it can rescind it at any point, but it's good for 6 months, and you can just keep re-signing them every 6 months if that's what they choose to do. I just recently had a grandparent who's had the kids for the last 10 years, and that's what they'd been doing for 10 years, and she's like, I'm done with it. We don't need to do this twice a year just for things I'm doing already. And it may be possible with a TDOP that, with just a temporary delegation of powers, that you may not be able to do some things like, I don't know how strict they are as far as applying for things like SNAP or Medicaid, but they may need a guardianship in place. And we can assist with a grandparent with a guardianship over minor children. So if it's within the will that they nominate, let's say the patient nominates a grandparent to take over and become guardian, that guardian, so grandparent, can file that in court, and that would allow them to become guardian, so within the probate court. But we can also help if there's no will and the patient has a poor prognosis, we can assist with getting a minor guardianship over the kids. Again, the other parent is always going to be a problem. So whether you file the guardianship and one parent has a poor prognosis or is okay with the guardianship, they're just not ready or not able to have the children at this time, you still have to deal with that other parent. If there's legally another parent, they are required to get some type of notice that the guardianship is going into place, and they have the ability to object. Grandparents' rights. So this is a grandparent can seek visitation if one of the parents is deceased, the marriage of the parents has been dissolved or is in the process of being dissolved, or the parents have never been married but paternity has been established. So those are 3 instances. In general, grandparents, I believe, in Nebraska will get 1 weekend per month. But you'd have to show the court a relationship between the grandparents and the children, that it's in the best interests of the children to continue to have that relationship, and you don't affect the parental time as well. So I had an instance, so this story was that Deborah was referred to help by a social worker after her daughter Farah was diagnosed with ovarian cancer and she passed away. There was a pending paternity action going, so I was able to have grandma step in as for her daughter and be able to establish some type of parenting plan. So Derek, the child's father, filed for custody. Farah passed shortly after, and we were able to get some type of visitation schedule. That one was a little bit more generous because the grandparents had been taking care of the kids for so long, and Dad was okay with it. But again, the standard in Nebraska is 1 weekend per month. That's all I have. I'm happy to answer any questions that anybody has. Also here with me today is Rosella Diba. She's been here for the last couple months. Emily Brisky is usually our attorney here. She recently had a baby, so I'm sure you guys can see plenty of baby pictures when she gets back in a couple weeks. But they're here every Wednesday from 1 to 4, so you always have access to them. You're always welcome to give me a call. All the referrals that you send come to me and my boss, Ann. And so if you ever have a question on whether to send one or not, we're always available to talk you through it and see if that's something that we can work with you on. So any questions you have for me? Yeah.
With child support, is it ever required that the parent show any kind of proof that they're using the money for the child?
So the question is does a parent who receives the child support, do they have to show proof that the child support is used for the child? No, not really, no. And also with child support and custody are separate, right? They're independent of each other. So you can't say, you can't see the kids this week because you missed your child support payment this month. That's not how it works. They are independent of each other. Yeah?
Is it illegal to file divorce so one person can get on Medicaid and, like, let's say they're $1 over or something like that. One has a lot of medical expenses. Is that?
So can a person intentionally file for divorce so that they can qualify for Medicaid? It's a no-fault state, so you don't need any specific reason to file for divorce. How that would look to Medicaid, I'm not sure. That might be the issue that you come up with, is say, oh, we filed for divorce, but we're still living together and we're still doing all this stuff. I'm pretty sure Medicaid might raise their eyebrows a little bit.
So what if they are on short-term or Social Security disability,
but there's other people that have to go to a facility, but they owe back taxes, and that can be garnished. Can that be garnished then if they have to use that for the facility for their own?
You're talking about arrears for if you're receiving SSDI and you still owe child support, and even if you're in a facility, can they take that money? Yes.
So the facility just doesn't get as much?
Yeah. And the state directly takes it. So when you get a notice like, your benefit has changed or whatever, they will show that the state is taking their portion to pay back their arrears. Sometimes you can negotiate how much is brought back or is withheld, but usually it's just a standard amount based upon how much you get, and they leave you a certain percentage afterwards. That's also true with spousal support as well. Any other questions? So again, I'm here. I can hang out for a little bit. If you guys have any questions that you want to come up to me and personally talk to me, I have cards here if you have any other questions. And thank you for having me.